Hello students, welcome back to our next moot court class, and the lecture which we are continuing with is Mootology and Mooting skills, and this is a continuation of the second lecture. This is a deep part of the second lecture, and this will be the last lecture of the chapter. So when you must rely on fairness to modify the strict application of the law, identify some jurisprudential maxim that supports you. A naked appeal to fairness is the face of seemingly contrary authority isn't like to succeed. Whenever possible, dress up the appeal with the citation of some venerable legal maxim that supports your point. Such maxims are numerous, mostly derived from equity practice. For example, when the reason for a rule ceases, so should the rule itself. One must not change this purpose to the injury of another. He who consents to an act is not wronged by it. Acquiescence in error takes away the right of objecting to it. No one can take advantage of his own wrong. He who takes the benefit must bear the burden. The law respects form less than substance. The state of California has codified many of these maxims. In fact, in India also we have a lot of legal maxims with cases summarizes exemplifying their applications. Court in other states are no less familiar with such maxims, and you can almost always find one to support a defensible position. Understand that reason is paramount with judges, and that overt appeal to the emotion is resented. It is often said that a jury argument will not play well to a judge. Indeed, it almost never will. The reason is rooted in the nature of what we typically think of as a jury argument, a blatant appeal to sympathy or other emotions as opposed to a logical application of the law of the facts before judges. Such an appeal should be avoided. Some authorities defend some degree of appeal to emotions. Every argument must be geared so as to appeal both to the emotions and to the intellect. I think the basic difference between a competent advocate and a great one is that a competent advocate can only do one or the other, or thinks only one or the other is important. You get competent advocates who are very good in emotional cases because they are adept in appealing to the emotions. You get competent advocates who are successful in cases that are on the dry side because they have the knack of appealing to the intellect. But a great advocate is one who can appeal to both and knows how to press the two appeals in such a way that one will not get in the way of the other. We hold strongly to a contrary view. It is both folly and discourtesy to deliver a jury speech to. It will surely win no votes. You are fortunate if the judges will attribute such misconduct to your ignorance rather than to the vulnerability of your case. Appealing to judges' emotions is misguided because it fundamentally mistakes their motivation. Good judges pride themselves on the rationality of their rulings and the separation of their personal proclivities, including some, most especially their emotions, and bad judges want to regarded as a good judges. So either way, overt appeal to emotions is likely to be regarded as an insult. There is a distinction between appeal to emotion and appeal to the judge's sense of justice, which, as we have said, is essential. Of course, you should argue that your proposed rule of law produces a more just result, both in the present case and in generality of cases, and that there is also a distinction between an overt appeal to emotion and the setting forth of facts that may engage the judge's emotion uninvited. You may safely work into your statement of facts that your client is an elderly widow seeking to retain her lifelong home, but don't make an overt, passionate attempt to play upon the judicial heartstring. It can have a nasty backlash. Assume a posture of respectful intellectual equality with the bench. The Solicitor General of the United States, the most frequently and often the most skilled advocate before the Supreme Court of the United States, is sometimes called the 10th Justice. Every advocate has the opportunity to deserve this description, to be so helpful to the court as to be a colleague of sorts, albeit a junior one. And that is the sort of relationship with the court. A relationship of respectful intellectual equality that counsels should try to establish. Some appellate judges refer to oral argument as the beginning of the court's conference, an initial deliberative session in which counsels participate. Intellectual equality requires you to know your stuff, to stand your ground, and to do so with equanimity. When you write your brief or stand up to speak, have clearly in mind this relationship that you wish to establish. It is not the relationship of a teacher to student. And if the judges get the impression that this is your view of things, you will have extinguished antagonize them. Nor is it the relationship of supplicant to benefactor. You are not there to cajole a favor out of the judges, but to help them understand what justice demands on the basis of your intimate knowledge of the fact and law. Perhaps the best image of the relationship you should be striving to establish is that of an experienced junior partner in your firm explaining a case to a highly intelligent senior partner. Respect for the court is more effectively displayed by the nature of your argument than by such loyally obsequiousness as "if your honor please" or "with all due respect." Of course, if you are going to err on the point, it is probably better to be unduly differential than not to differentiate enough. Restrain your emotions and don't accuse. Don't show indignation at the shoddy treatment your client has received or at the feeble and misleading arguments raised by opposing counsel. Describing that treatment and dissecting those arguments calmly and dispassionately will affect the court quite as much, and it won't introduce into the proceeding the antagonism that judges heartily dislike, nor will it impair your image as a reliable, rational, and ever tempered counselor. Ideally, you should evoke rather than display indignation. Cultivate a tone of civility showing that you are not blinded by passion. Don't accuse opposing counsels of chicanery or bad faith, even if there is some evidence of it. Your poker-faced public presumption must always be that an adversary has misspoken or has inadvertently erred, not that the adversary has deliberately tried to mislead the court. It's imperative, as an astute observer on the trial bench puts it, an attack on opposing counsel undercuts the persuasive force of any legal argument. The practice is uncalled for, unpleasant, and ineffective. This advice applies especially against casting in pejorative terms something that opposing counsel was fully entitled to do. Nor should you accuse the lower court of willful distortion, even if that is obvious. A straightforward recital of the facts will arouse whenever animosity the appellate court is capable of entertaining without detracting from the appearance of calm and equanimity that you want to project. If the court concludes that the law is against you, it will not award your client the victory just to embarrass a rogue trial judge. Control the semantic playing field. Labels are important. That's why people use euphemism and why names are periodically changed. And that's why you should think thoroughly the terminology of your case. Use names and words that favor your side of the argument. Consider American Airlines. Some lawyers who have represented the company call their clients AA in briefs, perhaps as a space saver that passes up an opportunity for the subliminal reinforcement. If American Airlines is your client, you have the opportunity to call your client American, knowing that every judge sitting on your case, unless you are in some international tribunal, will be an American. Of course, if you are opposed to American Airlines, you will call your adversary the company, the corporation, or perhaps even the carrier, never American. If you can get your adversary to use your terminology, so much the better. Sometimes it's not a proper name at issue but an event. Some years ago, Warren Christopher represented Union Oil in connection with some major spills at offshore oil platform in the Santa Barbara Channel. From the beginning, Christopher persistently referred to this potential environmental disaster as the incident. And soon, both the judge and even the plaintiff lawyer adopted this abstract word uniformly. Anything more concrete from Union Oil's point of view would have conjured up prejudicial images. Judge James L. Robertson of Mississippi has recounted a splendid example of his use of disputational semantic when he was in practice. He was challenging some unduly restrictive outside speaker regulation on Ole Missis College campuses. During the proceedings, He and his partner kept referring to the lawsuit as the speaker ban case. Soon everyone was doing it. That done, the outcome of the case seems to have been foreordained. Would you be inclined to vote for or against a speaker ban? Of course, semantic astuteness must not degenerate into sharp practice. In a high-profile medical malpractice action some years ago, a hospital executive named Lyman Sarnowski was accused of falsifying medical records. The plaintiff's lawyer repeatedly referred to him before the jury as Lyman, emphasizing the first syllable of his name to suggest undoubtedly that lying was part of his nature. It was not long before the judge ordered them to refer to the man as Mr. Sarnowski and levied a $5,000 sanction on the lawyer. Even if the judge had not taken offense, the jurors probably would have. Close powerfully and say explicitly what you think the court should do. Persuasively, arguments neither come to an abrupt halt nor trades off in a grab bag of minor points. The art of rhetoric features what is known as the peroration, the conclusion of arguments, which is meant to move the listener to act on what the preceding argument has logically described. The concluding paragraph of a legal argument cannot, of course, be as emotional as the peroration of Cicero's first oration against Catiline, but it should perform the same function appropriately for the differing context. It should be briefly called to the reader's or listener's mind the principal argument made earlier, and then describe why the rule of law established by those arguments must be vindicated. Because, for example, any other disposition would leave the bar and the lower courts in uncertainty and confusion, or would facilitate fraud, or would flood the court with the frivolous litigation, and so on. The treated phrase, for all the foregoing reasons, is hopelessly feeble. Say something forceful and vivid to sum up your points. So this was the end of lecture 2D, students. In the next class, we will continue with the next chapter and the series of lecture 3. Thank you so much. Have a great day.